I just wanted to sort of contextualise the sort of UK's position on data protection over the last few years. And going back to the pre-Brexit period, I appeared at this conference back in July 2012 and did a presentation called EU Data Protection, the First 6 Months. So it wasn't called GDPR in those days, but we were operating Ministry of Justice, who had the policy lead at the time, under a mandate of what was then the Conservative Liberal Democratic coalition government, which, you know, with hindsight probably seems like the epitome of political stability compared to now. But at the same time, both parties were actually absolutely clear on the UK's mandate. And I look back at my previous presentation, which I still have, and you know, look back with some degree of fondness. And what was the government position at the time? Well, it was included elements such as, you know, we felt that GDPR as it became was over-prescriptive. I think I described it as an over-decorated Christmas tree at the time. Right to be forgotten, a right inspired by social media, but how realistic is it? Of course, you know, subsequently we had the famous Costeja-Gonzalez case, which came in 2014. Administrative burdens, so hiring a data protection officer. Breach notification fatigue. Sound familiar already? The UK government assessed in November 2012 that the GDPR could potentially impose 130 to 320 million pounds a year on UK business. I wonder how accurate that figure was with the benefit of hindsight. Is it less or more? Leave you to draw your own conclusion, particularly if you've gone through a big GDPR transformation program. But there's some other elements which I think as well, which kind of translate into more forward-looking. So the need to maintain UK leadership in the digital economy. So is this something that the UK will be able to do in the post-Brexit scenario? Does Brexit effectively open the doors to the wider world and to really establish sort of UK leadership in the digital economy without necessarily being shackled by the EU, for example? And then taking into account cloud and apps as well. So that sounds rather quaint now, given all the other things about machine learning, ad tech, real-time bidding. It sounds rather sort of simple, simpler times, I think. And then overarching protection for EU citizens, but not over-regulation, which hinders growth and innovation. So I think even then we're still trying to sort of hit that balance between the free flow of data, which is, after all, part of the data protection regulation. We need to maintain that free flow of data in order to benefit society and individuals. And I think even in the recitals of GDPR, it says the free flow of data benefits mankind, which is quite a stunning thing to say when you think about it. But of course, the protection and having the high data protection rights. So it was essential to sort of strike that balance. But in terms of what the negotiating tensions were over the sort of subsequent 4 years after that 2012 presentation I gave, well, directive versus regulation. In the end, the UK's position on the directive didn't make it across the line. But in some ways, what has the regulation become subsequent to that? Numerous implementations of member state legislation where all the derogations and variations which are permissible under the GDPR have been exploited by some countries at least. And those of you who are familiar, of course, with the UK Data Protection Act will know that there are various derogations, for example, substantial public interest exemptions and so on, which are available to data controllers. The other tensions, of course, prescription versus risk-based approach, but also the idea of, the human rights side of things as well. So there were a couple of key moments during the negotiations, of course, Snowden and effectively the reinstatement of what was called the anti-Pfizer clause, Article 48 as it ended up being. Interestingly, the UK decided that under EU protocols, that particular article did not apply to them. And I think going forward, we've seen in the so-called UK GDPR that article has actually been deleted from the UK implementation of the data protection, or what will be the UK GDPR under the Data Protection Act. So those were the tensions, but of course, the stable government of the Conservative Liberal Democrat coalition came to an end in 2015. Political the political dynamics changed. David Cameron, as Prime Minister, called a referendum which was held on 23rd of June 2016, so over 3 years ago now. And as you know, 52% of voters voted to leave, 48% of voters voted to remain. And then subsequently, Theresa May became Prime Minister, and she invoked Article 50 of the Treaty on the European Union, which effectively set an exit date of the 29th of March 2019. And of course, we all know that the UK was forced to will effectively plead for not one but two extensions. So the new exit date is the 31st of October 2019, so Halloween, of course, so something to look forward to. But what does that mean in terms of the various outcomes which could happen? Now, assuming that there's not going to be any further delay, or alternatively that the government will revoke Article 50, which they are entitled to do following a judgment of the Court of Justice of the European Union, but politically that probably isn't going to happen. We're left with sort of two scenarios: the deal, so consisting of the withdrawal agreement and the political declaration on the future relationship between the EU and the UK. So these are these two documents which the European Council approved back in November of last year, effectively setting out the agreement. The withdrawal agreement, 585 pages. It does mention data protection in certain places, but ultimately it's effectively the divorce agreement. It also sets the transition period, which at the moment is set until the end of 2020, although there is a capacity for a further 1 or 2 year extension. And I think, seeing that some of the time has since gone since the original planned March exit date, it may well be the case that if this deal ever gets voted through by the UK Parliament, then they'd probably take advantage of the extended period. There's also the political declaration on the future relationship between the EU and the UK, and that's 26 pages long, so not such a heavy read, but it does promote data protection and privacy as a key element of the future relationship, and there is a sort of mutual recognition between the EU and the UK that high data protection standards should be maintained. So really, what does this mean? I think under the deal, this for everyone in this room, those of you who either work for companies or practitioners and advisors or regulators in the public sector, this is probably the easiest scenario to manage. If we do have that transition period, it should at least provide some room for an adequacy decision to be reached, and so effectively the European Union would determine that or the European Commission would determine that the UK is adequate and the free flow of data can be maintained. During that transition period, things will stay roughly the same. Certainly in terms of international data flows, they will stay the same. No deal though. This is a bit more of a dramatic scenario. Immediate third country status, and I'd refer everyone to the information notes that were published by the European Data Protection Board about the data transfer mechanisms that they should have in place, which, so for example, standard or ad hoc data protection clauses, BCRs, or exceptionally derogations to be used as a last resort. But I refer you to the useful information that EDPB have provided, and also there was a separate note as well on binding corporate rules. So if your organisation does hold binding corporate rules issued through the UK regulators, then they need to think about whether an alternative lead authority should be designated in terms of the management of those BCRs going forward. So I think Elizabeth will touch much more on the adequacy decision and or the negotiations which will hopefully lead to a decision. But what does this actually mean in terms of the UK's room for manoeuvre after Brexit? Well, you could say that the UK, going back to sort of my original comments, sort of contextualizing our relationship with the data protection regulation, is there the opportunity to make the rules a bit more business friendly? Is there the opportunity to reach out to the wider world? Is it possible to sort of maybe have that arm's length relationship like Switzerland does, and we'll hear from Urs later about how Switzerland interacts with the European Union as well. The government often talks about global Britain, I think. Do they still talk about that? I'm not sure. But anyway, you know, so there's some natural sort of geographical territories where the UK could potentially be influential or at least seek to collaborate and develop partnerships. So in particular, the British Commonwealth, but also other emerging economies as well. So I think those are interesting questions. Also, there'll be the question about the UK sort of making its own adequacy decisions, and really, you know, is there an opportunity to possibly deviate from the EU model, maybe look at other countries where potentially there is some benefit in having those free flow of data without necessarily being encumbered by the whole EU process. So some very interesting questions going forward.